to look at the file, and there was a question about whether the state had provided all the discovery. Is Ms. Sears or somebody covering from the Palmer DA's office on the phone?
Yes, Your Honor. Carrie Corliss, a Deputy District Attorney from the Palmer DA's office, Your Honor.
Thank you, Ms. Corliss. It looked to me like the Palmer DA thought that they'd provided everything.
That's correct, Your Honor. At our last hearing, Mr. Lawler had Mr. Stepovich stepping in for another one of Mr. Stepovich's associates. Mr. Stepovich advised that his associate believed that there was some outstanding discovery, but he could not articulate as to what that was. I asked Mr. Stepovich to either have himself or his associate email me and my colleague Jordan Markson with a request for what they believed was outstanding. We did not receive any such emails from Mr. Stepovich or his associate. It's my understanding that since the last hearing, Mr. Lawler has hired new counsel, so that probably explains the fact that we did not receive an email. So the state is still uncertain as to what the defense is indicating it's missing at this point in time.
Well, and it looks to me like the state provided all the discovery it thinks it needs to provide to Mr. Long at some point earlier on, and it just wasn't transferred. It may not have been transferred between defense attorneys. Is that the status from your point of view?
Judge, I'm not showing that as the status in our system, but I know that everything was provided back in December. So if that transfer took place before December, we would have complied with getting that information over. But I'll have to rely on the court's information regarding the timing of entry of appearances.
Most recent entry of appearance we have is from Mr. Musa, dated March 11th. So, Mr. Musa, do you think that there is outstanding discovery?
Your Honor, I don't know the difficulty by which the Palmer DA would be willing to just forward me any discovery that they sent to prior defense counsel. If they would be willing to do that, that would let me know whether or not they had something that I didn't have. I can tell you I don't have any digital discovery, so any body-worn cameras or anything of that sort I don't have. I do have a number of documents that my client provided to me, but, you know, if they'd be willing to go ahead and forward me whatever they sent to prior defense counsel, whom, you know, no defense counsel has sent me any discovery, so that would be immeasurably helpful.
Ms. Corliss, do you have a response to that?
Well, Judge, we did provide all the digital back in December to prior counsel. I don't know if Mr. Moose has reached out to them. We are very strapped for staffing out here in Palmer, so I suppose I can make efforts to resupply that, but I would also encourage Mr. Musa to get that from prior counsel.
Yeah, I don't know how many times the state is obligated to re-forward discovery that gets mislaid or lost or just isn't transferred. I haven't had to answer that question before, but I think there would be a reasonable limit on it. So I also encourage counsel to try to locate what they can. But it sounds like there's still, the defense still doesn't know or isn't able to tell me or a judge whether they've got everything that they need to have or not.
I know, Your Honor, that I've got enough to go on a couple motions that I have ready to file. However, we are 45 days past the defendant's arraignment, so I did file a motion for relief from pre-trial motion deadline. I was hoping that could be granted. In speaking with Ms. Markson, she said that she would not be agreeing to it and she would not be opposing to it. She said she would take no position on it. That was her statement.
Okay, I saw that motion. I was going to bring that up shortly here. Is that the Palmer DA's position, is that they take no position?
And I apologize, Your Honor, my colleague did not advise me that she had spoken to Mr. Musa about that at all. I take him at his word if that's his representation at this time.
Okay, is there, given that there's gonna have to be another hearing or two, probably in front of Judge Rankin. Is there any harm in me granting the motion and giving him a chance to file a dispositive motion?
No, Judge, as long as Your Honor puts another, motion deadline in place, that's reasonable, so we can keep the case moving.
Okay, let me find the motion and see what the request was.
Your Honor, I asked for 60 days. I'd be happy to accept 30. That was before I had drafted the motions. I have them both drafted, so now it's just a matter of filing.
Okay, I'll grant 30 days from today. Will be the deadline for filing the pre-trial motion.
Is that gonna waive Rule 45?
Thank you.
Any motion filed waived for 45 days.
And that's, we're gonna for the relief? Motion for relief?
Beg your pardon?
We're gonna for motion for relief?
Any motion,
Okay.
yeah. Unless there's a specific rule on point otherwise, but filing of any motion totals is 45. Okay, so it seems to me what we ought to do is set this back in front of Judge Rankin as soon as she gets back. And keep things moving forward. Do we have a date, Mr. Clerk? Pardon?
I'm waiting for them to.
Waiting for a response, okay.
What is the time frame you're looking for the next hearing?
I think Judge Rankin will be back in a couple of weeks, so we put it on, the parties should know by then whether they've got any remaining discovery issues, and have a pretty good idea of if it's gonna go to trial, if the dispositive motions don't work that are in the pipeline, when they'd be ready to go to trial.
So should I set like a status, say, 2 weeks out or 3 weeks out?
We're finding out, we're trying to contact Judge Rankin's chambers and find out what her schedule looks like. But I would expect.
Can you hear me?
I would expect 2 to 3 weeks out. Yeah, we can hear you. Are you not hearing me?
Okay. Yes, I am hearing. 2 to 3 weeks out, let's look at,
Oh, I'm sorry, that's Judge Rankin's JA speaking on the overhead.
yes, that is correct.
Yeah, shortly after she gets back, please.
How about April 1st at 2 o'clock?
You tell us.
Does that work for both parties?
That works for defense.
That'll work for the state and court, thank you.
Okay.
Okay, that'll be the next pretrial conference in the Lawler case. And
Thank you.
Because the motions have been filed, a motion has been filed that I just ruled on today, that told a little bit of time, that told between it was told anyway till today, I guess. So, we need to hear from, Mr. Musa if time should begin running again now, or are you gonna get those motions in pretty quickly?
They'll be in by the end of business tomorrow, Judge.
Okay. That'll toll time again. All right, any questions or issues that need to be addressed?
None from the defense, Your Honor. Thank you, and thank you, Ms. Corliss.
Yes, Mr. Russo, and Your Honor, just in the event that there is not a motion filed tomorrow, the state will file something, seeking to have the time told, because the state was not willing to take any time at this point. So I just wanna make it clear for the record, it's everyone's intention that there's going to be motions that we're gonna toll time.
Okay, I'm glad you put everybody on notice, thank you. Okay, that's it for the Lawler case. We'll move on to the.
This is MH, victim's mother.